Someone just died and you've been named as executor, or there's nobody else to deal with it and you have no idea what to do. This video is for you. And there's actually a way to skip probate entirely, or at least dramatically shorten it if the estate is small enough. And I'll tell you about that later on in the video. Hi guys, my name is Dan Schnurbusch. I'm an estate and probate attorney out of St. Charles, Missouri. We represent clients all across the state when it comes to matters involving probate administration when somebody passes away. First, do you even need probate? Not always. So it depends on how the property was titled at the time of the person's death. So there's what we call non-probate property that will transfer automatically at the time of death. So this would be stuff like life insurance that has a beneficiary, vehicles that have a TOD beneficiary listed, houses that have a beneficiary deed recorded with the Recorder of Deeds office prior to the person's passing, retirement plans that have a named beneficiary, things like that. Okay, all those things are going to pass automatically to the named beneficiary in most cases. There can be situations where this is not true, such as when a spouse gets divorced and things like that, but we won't get into those today. So what assets do require probate? These would be things like property that's left in their individual name that has no beneficiary. There's no joint owners that are surviving. Sometimes property can transfer automatically to a surviving joint owner. And that property, when there's property that's left in an individual person's name and has no beneficiary, no joint owner, that stuff usually has to go to probate. These would be like cars with no TOD and no joint owner, houses with somebody's sole name on the title, bank accounts with somebody's sole name on the account. These sorts of things generally are going to need to go to probate if they don't have a joint owner and don't have a beneficiary set on them. Now, if the entire estate, when you take the value of those accounts and minus any major debts, is less than $40,000, you might be able to go through a small estate process. This is much shorter than a typical probate administration, but in Missouri, at least, it does require you to go to probate still. It's just a lot shorter. In some smaller rural counties, you can get a small estate approved in a matter of days or weeks. In big counties like St. Louis City, St. Louis County, Jackson County, it might take a couple of months to get that through, but it still can be much faster than the typical 10 to 14 months that a traditional full administration process would take. And we'll talk more about that in a minute. Another way that you can quickly skip past a full probate administration is if you are the surviving spouse or surviving minor child or a surviving creditor of the deceased. If the value of the estate is under about $20,000 to $24,000 and you are a spouse or a minor child or the parent of a minor child, you can sometimes claim that estate pretty reliably depending on what county you're in. You can also file as a creditor if the total value of the estate is under $15,000 and there is no spouse or minor child. Most common situations that this applies are when you have like an adult child who paid the funeral bill. Let's say you paid $10,000 for a funeral and there's a $7,000 bank account and a $2,000 Toyota. Well, you might be able to claim those two assets as a creditor of the estate. And that one, the creditor refusal and the minor and spousal refusals, these are actually methods that's what they're called, is a spousal refusal of letters, a minor refusal of letters, or a creditor's refusal of letters. These are three of the only kinds of probate applications that can be filed without an attorney in the state of Missouri. Some counties will also let you file a small estate without an attorney, but big ones generally won't. Jackson, St. Louis City, St. Louis County are not going to let you file a small estate without an attorney. All right, so let's suppose that none of these small estate methods apply. The total value of the estate is over $40,000 and it's been less than a year since death. What do we need to do? In that kind of situation, we're generally looking at a full probate administration, which thankfully in Missouri is not as bad as it is in many other states. But it still generally takes somewhere between 10 to 14 months to complete the entire process. The first step is that if there is a will, that needs to be taken to the probate court and filed as soon as possible. We don't want to lose it, and it's important to understand that in Missouri, if that will is not filed within 1 year of death, it becomes completely invalid as a will going forward. Step two is there may be some things that the judge wants you to buy or purchase, such as a surety bond, unless it's waived in a will. If there is a will, the judge will review that will, and assuming it's valid, they will what's called probate the will, which means basically determine that it is the authoritative and binding document as to the deceased person's estate. Who it appoints as a representative becomes the controlling rule. How it distributes property, that becomes the controlling rule as well. Okay. So once they've probated the will, what will happen next is the judge will issue what are called letters testamentary. That is your formal seal of approval to take action on behalf of the deceased person's estate. And something to understand is that most people have an estate. It's just an estate doesn't mean you have like sweeping rolling hills of land. It just means that you have property in your name at your death. If there is no will, the judge will issue letters of administration, which are the same thing. It just has a different name when you don't have a will. Once letters are issued, a couple of things have to be done. One is that publication needs to occur in the newspaper to notify the whole world that, hey, if you have any interest in the estate or believe that you have an interest in the estate, speak now or forever hold your peace. This applies to creditors. It applies to, children who may not have been listed on the heirs list or something like that. It just gives everybody kind of a clear indication of, hey, it's time to go. This is the rule. This is the statutory notice requirement for the estate, is that we have to publish in the newspaper. Okay. Whenever we're handling probate, our office takes care of the publication process. That varies in cost. Sometimes in, more bigger counties like St. Louis County, St. Louis City, Jackson, the cost of publication is usually somewhere between $60 and $100. If you go out to more rural counties where there aren't as many newspapers and the newspaper space is more valuable for other things, you're competing with not just, estate publications, but a whole bunch of different publications, and the cost shoots up. In more rural counties, we've seen publication bills anywhere from $400 to $800. It can be very expensive to publish in the newspaper, but it is required to get the process started. The other thing that you're going to be required to do as soon as you're appointed is to put together an inventory of the deceased person's property. And there are specific rules about what has to be put on there, but generally speaking, anything that was in their name that caused you to need to go to probate in the first place needs to be listed on that inventory. You don't have to list anything that transferred as a transfer on death. You don't have to go through every fork and spoon in mom and dad's house. You have just a general, you'll itemize the important things that are required, like bank accounts and brokerage accounts and retirement plans and vehicles and houses and stuff like that. But everything else, personal property, is usually grouped into broad categories and only gone into more detail if for some reason one of the heirs or some other party requires it. Okay, now that we've got that publication out of the way, the clock is ticking. There's 6 months and 10 days before we're allowed to formally close the estate. The creditors at that point have a 6-month period to come in and try to file a creditor claim against the estate. In most situations, creditors don't do this. This would be things like healthcare bills, medical bills, credit cards, different kinds of private debts. Most of the time, people do not properly file a creditor claim against an estate. But when they do, there's a procedure for dealing with them. So, we notify the Department of Revenue, we notify the IRS, we notify Medicaid. We have to notify all these different agencies to make sure that if they think that they have a claim against the estate, that they go ahead and, get up and get it filed as soon as possible, so that we're not wasting time slowing everybody down, trying to figure this out at the 11th hour, or getting claims after the estate is already closed, for example. In the case of the government, they can do that, but other entities usually can't. So they've got that 6-month clock ticking. We've got the inventory filed. Now we're into open administration, where we're just handling the estate property, selling the stuff that needs to be sold, protecting the property, getting insurance on the property, vacant property insurance on houses and things like that, getting a house sold, retaining a real estate agent, and so on. We may need to have special orders to do these different things depending on how you're administering. It's supervised or unsupervised. If there's a will, generally you'll be unsupervised. You'll be able to take action without approval of the court. If there is no will, the only time you'll be able to do that is if all the heirs consent. They all sign a consent form. Okay? So if they don't do that, you're going to be supervised. You'll have to ask the judge for permission to do stuff like selling the house, selling the car, things like that, paying money, cutting checks to people. You have to ask the judge for permission. Okay? That's how a supervised estate works. So that's what's going on during that administration process, is we're dealing with property, dealing with creditor claims as they come in, paying any valid claims that the judge approves, and otherwise just kind of taking care of estate business, filing tax returns when you need to, things like that. Once that period is expired, after the 6 months and 10 days are over, we're going to start gearing the estate up for final settlement and closing. So a settlement is basically just a statement to the court of here's all the property that came in and out of the estate. We got $500 in dividends from this brokerage account over here, and we spent a couple $1,000s on an account, on legal fees, and all this other stuff. That's what the settlement is. It's showing the income and expenses of the estate during that set period. In a supervised estate, this is generally always going to be required. In an independently administered estate, the parties can actually waive this. The heirs can actually waive it in a signed document if they want to, depending on the county. Some counties won't let you waive the settlement, but most will. And we'll also be preparing things like the petition to do the final distribution, where we're saying, hey, judge, here's all the heirs. Here's the property we've got. Here's what happened over the last year. We want to distribute the property as follows. And in some cases, there'll need to be a hearing. In independent administration, there usually won't need to be a hearing, and the judge will just kind of approve whatever comes through unless there is an objection, which is not usually very common. So as I said, the general timeline is somewhere between 10 and 14 months. It can be slightly less. It can be a lot longer. At a minimum, it's usually about 8 to 9 because of the minimum statutory 6-month creditor period, all right? There can be all kinds of things that cause delays. It could be problems selling real estate. It could be the fact that we need to do a tax return before we can close. It could be disputes among the heirs. There could be all different things that could contribute to a delay. It could even be the court. In St. Louis City, for example, a lot of times we're waiting several months just to have a petition reviewed. It just depends on what county you're in, how long it can be. Sometimes things can be very quick. Sometimes they can take a really long time. A lot of different factors come into that equation. So let's talk for a minute about what Missouri probate costs. There are a bunch of different categories of cost. The most obvious one is the attorney's fee. And generally, the attorney's fee is going to range in an estate administration. There are several different ways that attorneys will charge fees for a full administration. In a supervised estate, they are generally set by statute. There's a minimum that applies. Now, in some cases, the attorney can ask for more than this. And in many cases, the attorney will keep track of their hourly rate and then try to take more if the minimum statutory percentage is not sufficient. This happens, for example, in situations where, let's say you have a house and it's worth $50,000 or $60,000, and you need to probate the house, but you're not selling it. In that kind of situation, the way the statute works out is that the minimum fee would be like zero because a house doesn't contribute to that formula that it gets applied. So you need to ask for more because obviously you can't handle a process for $0, right? So there are all kinds of situations where that will happen, but generally attorneys will charge either an hourly rate where they will just bill you by the hour and then send you a bill, or they will charge you on a flat rate like we do, and that will be paid out in stages throughout the case usually. And then overriding both the hourly and flat rate models is the statutory minimum percentage. Usually ranges between 2 and 4% of the estate, depending on how large it is. Larger estates, the percentage gets smaller, right? So that's the minimum floor that the law places on the fees allowed to the attorney. Now, what does this actually mean in dollar terms? It usually ranges anywhere from about $3,000 to about $8,000 to administer a probate estate in the state of Missouri. It can be less than that in some situations, and it can be a lot more than that, depending on who you work with and what's going on. I have seen bills by hourly billing attorneys in the $12,000, $15,000 range. We've never charged a bill that high in a probate estate. We try to prioritize efficiency and optimization, and that's why we do flat rate instead of hourly. We rely a lot on technology and automation that help kind of keep things moving, right? But when you do the old-fashioned way of have lots of people and billing lots of hours, the bills can get very high in some situations. So generally, though, you're not going to look at fees that high. At our firm, for example, the typical fees range from about $3,000 to $7,000, $8,000. Okay, that's the big one. Now, it's also important to understand that the representative themselves, the person handling the probate, is entitled to a fee. This is kind of one of the second categories of fees that apply to administer an estate. And they are also entitled to the same minimum statutory percentage. So if the minimum statute says the attorney is entitled to $6,000, so is the representative. They're also entitled to an additional $6,000 out of the estate off the top. Okay? It's another category of cost associated with administration of probate. You don't have to take this, but many people do. Other costs, things like the surety bond. You're going to have to, in most cases, buy a surety bond to protect the estate from fraud or mismanagement. It's kind of like an insurance policy that if you decide to steal the money, the heirs or other aggrieved parties have the opportunity to make a claim against the bond. Okay. Now, the bonds tend to range anywhere from $100 to a few $100s, even on very large bonds. Like even $100,000, $200,000 bond might only be $300-$400. Okay, and that's usually paid on an annual basis, right? Out of the estate property. So it's either out of the estate property or reimbursed to you. If you paid out of your pocket, you can usually get that reimbursed to you. Okay, so that's another category. Publication costs, like I said, usually from $60 to several $100. Could be a range. Court filing fees are another category of costs. Those are usually a few $100s. So, these sorts of things can add up, as you can see. But there are ways to plan around it through the use of things like transfer on death and trust, just like we talked about at the beginning of the video, that there are all kinds of property that just doesn't go through probate at all, right? So that's a little bit about cost and how to think about where is this gonna go and how much is this gonna eat into your inheritance. Other costs you might see is CPAs to do accounting returns, real estate agents if you need to retain them to sell real estate, for example. So it depends on. So other costs kind of depend on the situation of the estate. Okay. So what happens if you don't go to probate? This is going to depend entirely on the situation of your assets. So it's a little hard to give some general rules, but I'll give you an example. Like, let's say you have a house that's in mom and dad's name and you can't sell it because the bank says, hey, it's in mom and dad's name. If you don't go to probate, in many situations, the bank or title company, in many situations, you may not be able to sell or finance the property. Eventually, after a year of death, you may be able to enter what's called an affidavit of heirship and show the transfer of title in the title records and avoid the need for probate on that specific piece of property. But in the meantime, at least, you may not be able to sell the property or refinance the property, and you may not be able to, depending on the mortgage company and what the status of the mortgage is, you may or may not be able to continue making payments on that mortgage. If the property was in default, for example, they may decide, hey, we're not going to take your payments anymore and give you trouble, right? If you don't probate a car, you pretty much have to give it to the junkyard and treat it as abandoned, because there's no other way in Missouri to get a car out of a deceased person's name into the name of the family without going through probate unless there's a transfer on death on it. If you don't probate a bank account or life insurance proceeds or other cash or stock options or things like that, they will typically be given to unclaimed property, and unclaimed property will generally require you to go to probate. So the fact of the matter is, like, if there's something in somebody's name that does not have a beneficiary and does not have a joint owner, most of the time you will just not receive that piece of property if you don't go to probate. That's pretty much the long and short of it. The other thing to be aware of is if they did have a will and you want that will to be authoritative and you don't go to probate for a year, you can never use that will again. This is very important in situations where, like, maybe the will cuts out a child or changes what would have been the default distribution. In those situations, it's very, very important to get that will taken to court and admitted to probate. And those are two different things. Filing a will is not the same as admitting it to probate. You have to first file a will to get into the court record and then file a petition to admit the will to probate, which is a separate filing where you're actually asking the judge, hey, judge, now that this will is filed, can you take a look at it and make sure it's valid? You have to notify people and make sure everybody's aware that the will is being admitted to probate. Now, the upside is that you can still go to probate after a year. It's just a different kind of probate. Small estates still work, but there's a different method called a determination of heirship. If the property is over $40,000 and it's been over a year, you can often resolve probate with a simple court hearing, right? It usually takes anywhere from 8 to 10 weeks instead of a year. And it is generally very quick and it can be an effective way of distributing and transferring property from a deceased person into the name of their heirs without going through the whole process. The other advantages of a determination of heirship and waiting out the year is that creditors can't file anymore. You don't have to worry about a will or anything like that. In some cases, it just makes sense to wait out the year. And because it blocks creditors and it allows you to simplify the probate process, especially if you're on the line. Let's say you're 9 or 10 or 11 months out and from the decedent's passing, and the 1 year mark is coming up here pretty soon. In many cases, it's a good idea to make that decision intelligently with an attorney as to should we open today versus should we wait out the year. But a lot of times, if there is no will, waiting out the year is often a better option. Something to keep in mind. A couple of things to gather as you get started on this process. You need to make sure you have a death certificate. If there are bank accounts, you need to try to get a bank statement. Sometimes the bank won't talk to you. If you're dealing with real estate, it can be helpful to go call the recorder of deeds office and see if there's a beneficiary deed on file. See if you can get a copy of the original deed. If your deceased loved one had gone through a divorce and the house had been shuffled up in that way, see if you can get a copy of that divorce decree. Things like that. Getting documents relevant to the assets that we're dealing with. So things like car titles, deeds for houses, statements for bank and brokerage accounts, things like that. Those are some good first steps and things to start collecting so that you can get started intelligently for the probate process. So you don't have to figure this out alone. In most cases, you're not even allowed to in the state of Missouri. So again, my name is Dan Schnurbusch. I'm the owner of Schnurbusch Law, and we deal with probate in the state administration across the state of Missouri. So if you're kind of dealing with this situation, feel free to watch more of our videos to learn more about probate. Otherwise, give us a call and we'll see if we can help. See you in the next video.